As you know, my name is Tawshunsky. I've been asked to say a few words about compliance for ACA, and I think there's a few points to note. One is that the rules now are mostly going into effect fully. There has been relief on employer pay or play provisions in 2014 across the board, and in 2015 for some employers who would otherwise be subject to it, but those are now going fully into effect. There's now, I think there was a fair amount of relief on reporting for 2015 for employers who, given extra time, and I think the IRS will be a little bit more relaxed in terms of enforcing timeliness and accuracy as long as you make a good faith effort to get the forms in on time and correct them if there are problems. But again, going forward, we're getting past some of these transition rules, and so the compliance status is becoming more, let's say, rigorous. So I think that is something, is to make sure that systems are in place for complying. Another, I think there's been a lot of concern with notices that employers have been getting from the exchanges where their employees become eligible for coverage and receive a premium tax credit. And I know employers have been working on, should they answer, what happens if I don't answer, what happens if the exchange is not satisfied with my answer. And I think to try to give some reassurance there, the real process for employer penalties is with the IRS at the end of the year. So that regardless of what happens with the exchanges, the IRS is going to look at the returns filed by the employee. It's going to look at the information returns, the 1094s and 1095s that are filed by the employer at the end of the year. There will be matching of those. There'll be a process to resolve that. So if you are concerned that your employee may not be giving accurate information to the exchange, or that the exchange may not accept your explanation, that's not really the determining factor. The determining factor is the IRS process. And there's also been concern about the amount of documentation that's needed. And there are really not special rules for documenting an offer. It's really the same level of documentation that's required generally for tax purposes by the IRS. And so as long as you've got your systems in place, that would be sufficient to deal with an examination. Otherwise, that should serve for this purpose as well.